Good morning. Welcome to the Supreme Court of the United Kingdom. This morning, the Supreme Court is handing down its judgments in two cases, General Dynamics United Kingdom Limited and the State of Libya, and Director of Public Prosecutions and Ziegler and others. General Dynamics United Kingdom Limited and the State of Libya concerns the rules which govern the service of documents in proceedings to enforce an arbitration award against a foreign state. The case arises from arbitration proceedings brought by the Respondent, General Dynamics, against the Appellant, the State of Libya, in which General Dynamics claimed money owing to it under a contract for the supply of communication systems. On the 5th of January 2016, an international arbitration tribunal in Geneva issued an award of over £16 million plus interests and costs in favour of General Dynamics. Libya has made no payment of the sum awarded. General Dynamics has accordingly taken action to enforce the award. On the 20th of July 2018, the High Court made an order which granted General Dynamics permission to enforce the award in England and Wales. In the light of evidence of civil unrest and political instability in Libya, the Court decided that General Dynamics did not need to effect formal service of this order on Libya. Libya applied to vary the High Court's order so as to require General Dynamics to follow the procedure for service prescribed by Section 12, subsection 1 of the State Immunity Act, 1978. Under that provision, quote, any writ or other document required to be served for instituting proceedings against a state, unquote, must be transmitted to the relevant state's Ministry of Foreign Affairs through the United Kingdom Foreign, Commonwealth and Development Office, the FCDO. Libya's application was successful at first instance, but on General Dynamics' appeal, the Court of Appeal decided that Section 12, subsection 1 did not apply in this case, and that the High Court's original order, which dispensed with service, should be restored. Libya now appeals to the Supreme Court. By a majority, the Supreme Court allows the appeal. The majority, Lord Lloyd-Jones, Lady Arden, and Lord Burrows, consider that the procedure for service in Section 12, subsection 1 of the State Immunity Act is required to be followed in all cases where proceedings are commenced against a defendant state. In cases to which Section 12, subsection 1 applies, the procedure for service, which it establishes, is mandatory and exclusive, subject only to the possibility of service in an alternative manner agreed by the defendant state in accordance with Section 12, subsection 6. The majority explained that this interpretation accords with the clear language and purpose of Section 12 and is strongly supported by considerations of international law and comity. It is essential that a defendant state is given proper notice of proceedings brought against it and is afforded a fair opportunity to respond. In the particular context of proceedings to enforce an arbitration award against a foreign state, the majority conclude that the document which must be served in accordance with the procedure in Section 12, subsection 1, is the arbitration claim form, in a case where the court requires one to be served, or the order granting permission to enforce the arbitration award, where, as in this case, the court does not require an arbitration claim form to be served. In their view, the Court of Appeal was wrong to decide otherwise. It is argued on behalf of General Dynamics that the Court of Appeal's decision, nonetheless, should be upheld on the basis that even if Section 12, subsection 1 of the State Immunity Act applies, the Court has power to dispense with service under Rules 6.16 and or 6.28 of the Civil Procedure Rules. The majority of the Court do not accept this argument. There is nothing in Section 12 of the State Immunity Act which indicates an intention that the content of the obligation to effect service through the FCDO is to be determined by reference to the Civil Procedure Rules. Furthermore, the scope of the Court's power to dispense with service under these rules is limited by Rule 6.1a, which provides that these rules do not apply where another enactment makes different provision for the service of documents. This makes clear that, in this instance, the Civil Procedure Rules do not purport to oust the requirements of Section 12 of the State Immunity Act. In any event, the rules could not give the court a discretion to dispense with the statutory requirement. It's also argued on behalf of General Dynamics that Section 12 of the State Immunity Act should be interpreted as allowing the court to make alternative directions as to service in exceptional circumstances where the claimant's right of access to the court would otherwise be infringed. The majority of the court reject this argument too. In the view of the majority, Section 12 of the State Immunity Act provides a workable means of effecting service which is in conformity with the requirements of both international law and comity in an area of considerable sensitivity. The procedure cannot be considered to infringe General Dynamics' right of access to a court, such that a different approach to the interpretation of Section 12 would be required either under the Human Rights Act 1998 or at common law. A.D. Arden delivers a concurring judgment. In his dissenting judgment, Lord Stevens, with whom Lord Briggs agrees, considers that Parliament intended the applicability of Section 12, subsection 1 of the State Immunity Act to depend on what was required by the relevant rules of court. Documents which do not institute proceedings, such as the enforcement order, fall outside its scope. Furthermore, the minority consider that even if Section 12, subsection 1 applies, in exceptional circumstances the court can dispense with service of the enforcement order. Finally, the minority interprets Section 12, subsection 1 as allowing the court to make alternative directions as to service if the claimant's right of access to the court would otherwise be infringed. For these reasons, by a majority, the Supreme Court allows Libya's appeal. General Dynamics is required to serve the order granting it permission to enforce the arbitration award on Libya in accordance with Section 12, subsection 1 of the State Immunity Act 1978.